I thought it was a well-written article. Unfortunately, it addressed only the claims, did not address the real issue, and that is, how do we avoid claims? How do we not put our insured into that uncomfortable spot of having to talk to attorneys, trying to resolve an issue that should have been resolved prior to closing?
Okay.
The commitment process allows us to look and review this document to discuss easements, covenants, conditions, and restrictions, agreements. If it is not questioned, if dialogue is not generated, everybody has failed. Real estate professionals have failed. The buyer didn't ask the questions. Eventually, it will become an issue. It becomes a claim.
Okay. Have you had situations where, as an example, that you've been able to avoid this?
Our most recent example would be an easement. The easement did not reach all the way to the client's subject property, and it did not contain maintenance language. We got the easement extended so it did reach the client's property. Maintenance language was brought in. Neighbor signed off on the document. Time and money spent resolving the issue prevented the claim, time and money spent after the deal is closed. Always better for the client and the buyer to have these issues resolved beforehand than dealing with a large bureaucracy at the end and spending time and money on attorney's fees to resolve the issue.
So how did the situation get to you then?
The buyer questioned it. The agent asked me if I could look further into the issue. Running out the legal descriptions on the document, we discovered indeed that it didn't. I sent an inspector out. They confirmed. We started to bring other professional parties into it. We had to bring in an attorney to resolve it, but it got resolved, and that's the important issue here. The question was asked, dialogue was generated, and a resolution that was equitable for our parties was reached, and all parties walked away knowing that the issue had been resolved.
So with this issue, so you have an easement and a maintenance agreement. First of all, there was no maintenance agreement at all.
Right.
So would this have been a legitimate claim?
Probably not. The easement not reaching to the subject property we had insured together with, we would have had a potential claim there that would have been turned over to our legal staff to review. The maintenance language had come from the lender at some point in time. If they didn't see it, could have been a potential issue.
Right.
Again, the only way we know if it is an issue is if we're talking about it. If we're looking to find and the most important point is to ask the question so we can define the issue that we're looking at and so that we can get the answers that will resolve that issue. Again, if we're not talking about it, I always know we're in a claim situation when I get a call either from the insured or from the agent who represented them going, we think we have a claim. Did we talk about this? Was there any discussion? Right away, I'm thinking if we didn't talk about it, we at least have an issue and we potentially have a claim.
Right. Not to mention you're going to have two neighbors that aren't going to be that fond of each other without getting this done up front.
Right. Part of the process should be not only possession of the property, but peaceful enjoyment of the property. You find yourself in a claim situation, you have possession, but you will not have peaceful enjoyment until that issue is resolved.
And even after it's resolved, you may not have
peaceful enjoyment.
Yeah.
Yeah. You may not be sharing a beer and a burger at the neighborhood barbecue. That's for sure.